the sun. To dream, believe in strength now.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to report on the Idaho 4 case. And we've got some bombshell docs that have dropped, and there is so much information that we can glean from it. And I'm going to report it in this episode. And it's amazing to me. Several things are amazing to me. There's so much amazing. The defense team, in this case, I feel like is just exceptional. And I think what they're having to do is they're having to jump so many hurdles because of the pressure from the false narratives in the media that they have to literally, I've said it many times, they have to literally play 3D chess. And when I say that, what I mean is that they have to do things on strategic levels that are mind-boggling. And I'm going to show you that in this one, because I'm going to show you why they were bringing so much attention from the media to the fact that there was, let's just say, unconstitutional searches with those databases. But meaning the whole defense team, they had to bring in that aspect of the case so that the media would want to pay closer attention and give a dog a bone so that they would focus in on that aspect. But then she could shift everything to the real issue. And the real issue is not unconstitutional searches. The real issue is the fact that the prosecution and all of the law enforcement involved in the case will not provide the discovery for any of it. And by bringing the media's attention onto a potential unconstitutional search where they're going to dive in and go, oh, there's a wrong here, it's going to bring eyes on the fact that they cannot get that information. Everybody has missed what their real argument was in that hearing. And it wasn't on going into databases they weren't supposed to go into. The real argument was, and she said it about 18 times, is we don't know. They won't give us the information. It was done in secret. It is a secret thing. We don't have what happened to this stuff once it left the lab. We can't trust the FBI or law enforcement because of this reason, this reason, this reason, this reason. So why do we trust them when it comes to the DNA portion? That was the point that they were making over and over. And I can show you 15 clips, but I'm not going to do that in this one because there's too much other information to cover with these new court docs. But the pressure is mounting and it's starting to work. We've got a declaration from Hippler in this one where I'll save it to the end, but we're going to get some information on that closed hearing. Let me just tell you that. But here's the real problem. It's investigative journalism. You see, here's how investigative journalism works. And you want to know why the media is so compliant with pushing false narratives out there? All you have to do is turn on court TV as it relates to this case, and they'll have up on the screen, I mean, it makes you want to punch the TV screen in, but TVs are actually pretty cheap these days, so I ought to just go in there and knock that TV off my wall. But when you have court TV on the screen as they're discussing that hearing, and it says, Bryan Kohberger followed 3 of the victims on Instagram. Like, what? What do you mean followed 3 of the victims on Instagram? The defense and the prosecution just admitted in another hearing. There's no connection to them from following accounts. There's no connection online, period. They still have that stuff up on their screen. Followed 3 victims on Instagram. I mean, it's just lies. But why would they do that? You've got to understand this. And it's the fall of investigative journalism. You see, investigative journalism in the past was you would have a journalist who was an investigator, and they would start investigating a case. And then to verify their findings, they would locate sources within their scope of the investigation. And then they would either confirm or let them know that they're going in the wrong direction based on confidential sourcing and say, okay, yeah, what you're investigating there is true. And then they get a statement and they go, okay, this story is verified. I got 2 sources that verified my investigation. That doesn't happen anymore because today people are lazy. So here's how it works today. Today, instead of them getting out and investigating, they call their sources within a case, and their sources tell them, we want you to do this, report it this way, and then I will keep feeding you information. Instead of building a real investigation and corroborating through real sources, they use their little sources within an area to dictate to them what to say so that they will continue to give them information as a confidential source, which is totally different when I talk about a confidential source as it relates to law enforcement. I'm talking about confidential sources within law enforcement, within the court. You know, they all those journalists like Nancy Grace, she's got some little confidential source. Ashley Banfield got some little confidential source. And those confidential sources will promise them nuggets if they report something a certain way. And instead of them getting out and doing real investigative journalism and then verifying with a confidential source, they'll sit on their butts, let those people dictate what they do so that they'll feed them more information down the road. That is a fact. And that has got to change. We need some real people, kids out there that are in school going to journalism class. If your teachers are teaching you that crap, get rid of those teachers, go get an old book, learn it, and then get out there and do it the right way. Because that's what we need in this country, because that's what keeps everything straight. It's the people of this country that have gotten lazy over the last 15 years that are causing these problems for us. But in this episode, we're going through these court docs. I'm going to show you some real pearls, and we got some real things that are going to be happening. But we also have some real problems, and that's what we're going to see in these docs. So without further ado, we're going to jump right into it. The first one is going to be the judge's order as it relates to the media starting to put that pressure. They wanted everything unsealed. Well, the judge had to make an order for that, and in that order, he's ordering on, this is the order for not opening the hearing, which we'll see another doc came out, though, today, or maybe late last night, where the pressure has been felt by the judge. But we're going to go in order on these things. So let's jump in. Okay, we're going to start off here. And you can see this is an order denying motion to unseal IGG suppression briefing and hearing. Denying the motion to unseal it. Okay. Defendant's motion to unseal the IGG suppression briefing and hearing on January 13th, 2025. That's when they filed the motion. I was like, wait, whoa, what hearing was this? All right, hearing on the motion was held on the 21st, 2025, during which the court denied the motion from the bench, and this order memorializes that ruling. It's memorializing that ruling. That's interesting. Interesting verbiage there. This order memorializes that ruling. As the defendant has observed, this case has garnered intense, if not overwhelming, national and international attention in the media. You don't say. This has led to the sealing of several filings in this case pursuant to ICAR 32, which contemplates sealing information temporarily. So, according to this, we should all get to see all this information as it comes out at some point, when necessary to preserve the right to a fair trial. And then it goes on to say further, Judge, then presiding, entered a comprehensive non-dissemination order to prevent publicity about evidence that may or may not be ultimately admitted at trial from tainting a prospective jury pool. Among the sealed filings is the briefing on defendant's motion to suppress RE genetic information, November 14, 2024, which parties stipulated to filing under seal. Defendant seeks to unseal this briefing, as well as the hearing on the suppression motion. He points out that the public has long been aware that law enforcement used investigative genetic genealogy procedures in this investigation, in investigating this case. However, because the details of the IGG investigation have been withheld from the public, defendant contends there is significant and prejudicial misinformation circulating in the public about his guilt. You don't say. Significant and prejudicial misinformation circulating in the public eye about his guilt. About his guilt. Guilters. Unsealing, he argues, will correct such misinformation, protect his Sixth Amendment right to a public trial, and preserve the public's First Amendment right to know what is going on in its courts. The state responds that it has no objection to unsealing the IGG evidence after trial. Yeah, we have no problem unsealing it after the trial, after we get our conviction, but doing so prior to the trial poses a significant risk of tainting the jury pool. The court agrees. So it's going to taint the jury pool. For which side there, Judge? You can see that's my notes. Which side are you worried about tainting the jury pool for? Because the other side against Bryan Kohberger and his guilt have already been tainted to 90%. What you're saying is this risks the tainting of the jury pool to make this more even. That's why you want to let it come out after trial, so everybody can be just, perplexed at how they got a guilty verdict with this information that never came out, much like that Delphi case, when all the information after the trial comes out. Yeah, that's what you want. But this footnote here, I think, is very important. We're going to dive into it. And it says the IGG was raised as an issue in this case in defendant's third motion to compel discovery, June 22nd. The court previously handling this matter held a public hearing on the motion, which included testimony by 4 expert witnesses. The court ordered production of records in camera and under seal. Sealed order for disclosure of IGG information and protective order, December 29th. Defendant then sought additional IGG evidence through his 5th motion to compel discovery in 2024. Over defendant's objection, the court required the hearing on the motion to be closed and ordered the production of records under seal. Order granting state's motion to close May 14th hearing. Order on defendant's 4th and 5th motions to compel discovery on June 14th. So the defense has requested all of this information in their motions to compel, mainly from their very first motion to compel. And the court has ordered over and over for them to get this information. And what did we hear in this hearing over and over and over? We heard, we did not get the information. It's held in the dark. We don't know what happened. This is some BS, right? And it's been ordered by the court for them to have that information over and over and over.
That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret.
That entire segment of this case is secret. So we've got to go all the way back to right here. The third, like in his footnote says, now this tells me, y'all, this footnote right here, that Judge Hippler has now probably lost several more hairs as he's done this, but he has now gone through the court record and he's been able to identify, starting with the third motion to compel, where the court has ordered for this information, on all these motions to compel and all of these orders by the court. And he now knows that The defense has asked for it many times, compelled it. The judge has ordered it many times, and he knows that the defense still does not have it. And I'm going to show you at the end of this where the judge is coming around to the defense's woes in this case. But we've got to go back, before I go any further on this, we've got to go back to this third motion to compel discovery on June 22nd, 2023 to truly understand the travesty in this case. And here it is. We've got defendant's third motion to compel discovery. And you can see Bryan Kohberger, through his attorney and public defender, pursuant to Idaho Criminal Rule 16, moves the court and requires that this is the discovery that he wants. And I want you to look at this. This is ridiculous. Because what does it say right here at the top? Mr. Kohberger requests an order for the state to disclose the following items included in defendant's third supplemental request for discovery. What does this right here say? It says standard lab discovery. Standard lab discovery. Every case that you have this type of evidence, this would be the standard discovery that you would want to have. This isn't like they're asking for something that, some nuanced discovery request. This is standard. And in the event that the case involves the upload of a DNA profile to either a local, state, or national database, and I've focused so hard on the national database, which is the CODIS system. I didn't even know they had a local and a state database. Please provide all the documentation maintained by the testing laboratory, including documentation maintained by Combined DNA Index System CODIS personnel within the laboratory, including profiles that have been identified as unknown males, not the defendant. This brings up, though, this is kind of important. This brings up with this local, state, and national database system. When they first entered the STR profile, did they enter it into NDIS? Or did they just do the SDIS or the LDIS, state database, local database? And that's an important question because the national database actually now requires 13 loci, but the state database doesn't. The state, now I don't even know what the minimum is on the local database, but the state database only requires 6. So you can get a match a lot easier with the state database than you can with the national database because of the lower requirement of the loci. And I'll show you all that here in just a minute. But it's just crazy. And this is why you would want all this discovery. Documentation of all uploads, including interpretation. Interpretation is very important in this case. And or deconvolutions of mixed profiles, handwritten notes, spreadsheets, match estimator results, upload forms, and CODIS search forms. For each hit, please provide match detail reports and long-form candidate match reports for the hits, including partial hits and hits that are dispositioned to be non-matching, even if the laboratory has dispositioned a profile as a hit. Any state manuals regarding the use of the state database or the national database systems. Any hits made to any profile uploaded, even if they hit on individuals, not the defendant. And deemed to not be candidate matches, including hits to any unknown males identified via testing. The state has provided information related to this request for the DNA on the snap of the knife sheath only. So they didn't provide, look at this. This is huge. The state has provided information related to this request for the DNA on the snap of the knife sheath only. Now, how much DNA was in that house? Can you possibly, imagine how many samples of DNA that they ran in that house? And they will only give the defense the report from the button snap of the sheath. It's like, don't look at anything else. Here's this knife sheath with this button snap. This is all we're going to give you because this is all we've had time to manipulate. And the defense has requested all DNA profiles, including additional profiles developed during the course of law enforcement investigation. See the declarations of counsel. They want the communications, all communications between laboratory personnel and any other party regarding biological testing in this case, including letters, memos, emails, texts, and records of telephone conversations. These materials should include communications with regard to outsourcing of DNA testing, statistical calculations, and DNA profiles uploaded to a database. So, standard, right? What does it say up here? Standard lab discovery. Communications is part of that. All emails, text messages, electronic messages, or other messages have not been provided. See declarations from Mr. Kohberger, from Bicca, and Steve Mercer filed simultaneously. Have not been provided, and it is standard lab discovery. Unexpected results in corrective actions. Oh, corrective actions. For each laboratory that performed DNA testing in this case, please provide copies of the laboratory's logs of unexpected results. Unexpected results and corrective actions were requested for the 6 months before and 6 months after testing related to the case. Only entries relating to lab personnel in this case were provided. See, they want the results for unexpected results for other cases, 6 months prior and 6 months after, to see if there has been errors before that they can point to in their procedures. But they didn't get that. Only entries relating to lab personnel in this case were provided. And that is, again, standard lab discovery. Genetic genealogy testing and search. They wanted all reports generated by any lab conducting S&P testing. Now look at this, by any lab conducting S&P testing on any sample in this case, including from samples where unknown males, not the defendant, were identified. They want copies of all communication between laboratory personnel and any other person or organization with regard to the instant case, including letters, memos, emails, internet posts, press releases, and records of other communications, including communications with regard to any DNA profile uploaded to any public or private DNA database. All documentation associated with any database search, including but not limited to CODIS, NDIS, which are really the same thing, GED match, family tree DNA, or a felon database, case sample databases, missing person databases. Whoa, when it says missing person databases, that's mitochondrial DNA. Only thing you're supposed to upload to a missing person database, as we've learned in our research, is mitochondrial DNA. And internal quality assurances database. The documentation should include, but is not limited to, the input profile, the input search, parameters, search output, all reports, correspondence, and any follow-up actions. All documents related to any genetic genealogy search, including but not limited to the creation of a user profile, accounts, information, automatic search results, uploading of data, all queries and search results from public databases, family tree information, and all documents, reports, notes, or other communications pertaining to genealogy DNA database searches. All documents related to any genetic genealogy investigation, including but not limited to additional collection, testing of DNA samples, notes of interviews, documents obtained in ancestry, and/or recommendations for further testing. All documents related to the comparison of any DNA samples collected during the genealogy investigation to the crime scene evidence. All of this is standard lab discovery. This was back on June 22nd, 2023, right after the grand jury indicted Kohberger in lieu of that what? That preliminary hearing that would have released him. The name and addresses of all persons found to have sufficient sharing symptomorgans with the subject profile to be identified as a match in the report created in this case. And what happened? The state has objected to this discovery request. The state has objected to this discovery request, even though this is standard lab discovery. Why would the state object to it? Further, the state has filed a motion for a protective order. So they're objecting, they're trying to get it protected. Mr. Kohberger incorporates herein his objection to the state's motion for protective order, as well as declarations of counsel for Mr. Kohberger, Bicka Barlow, Steve Mercer, in support of defendant's motion to compel. Now, all of this information, as standard lab discovery, should be provided to the defense. All of it. The state objects. The defense files replies, declarations to their objection. What does the judge say? He talks about all of the court ordered the production of records in camera and under seal. And he had a sealed order for disclosure of the IDGG information. And the order granting state's motion to close, order on defendants, fourth and fifth motion to compel discovery. So even John Judge has ordered that the prosecution and law enforcement turn over this information. And Stephen Hippler now knows about all of these orders. But what has happened in the case? Did they turn all this stuff over to the defense?
We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances.
That's why Ann Taylor wanted everything out into the public. It wasn't to show that it was an unconstitutional search of Bryan Kohberger's DNA in some database that led to Bryan Kohberger and, let me get my client off on a technicality. She wanted that out there because it's the only way that the media will actually take a look at this case in the proper way. If she brings up unconstitutional searches, that piques their interest. We'll look into this. And then she has the ability to say, look, we never got any of this stuff that we're supposed to get in a standard discovery. In any case that relates to DNA. We have got nothing. The only thing we do have is a bunch of secret information that supposedly led to Bryan Kohberger, and in the process has probably been manipulated to fit Bryan Kohberger. And it's plain as day when you look at the original request for discovery, all the orders for what they should have at this point, and then you hear in that hearing that we learned this the first time this week, and we still don't have this, and this. It is a travesty. And her argument throughout this is things that the prosecution, things that the law enforcement did in this investigation, specifically the FBI, lied about this aspect, this aspect, this aspect, this aspect. So if they're lying about aspects that we can prove they're lying about, how are we supposed to rely on the information that they won't give us as it regards to the DNA? But more importantly, Hippler now knows this. Hippler is a smart guy, and I kind of feel for him. I know I've called him Hitler, and he is absolutely biased towards the prosecution in this case. However, he is a very smart guy, and he's able to pick up on information. You got to think about it. He's only been on this case for a couple of months. This case has been going on for a long time. There's been a lot of stuff happen in this case. He's learning it for the first time, but he's starting to really learn it. And the more that he learns, the more his eyes are going to be open. And because the media, this is the genius move by Ann Taylor and team. Because they brought up the unconstitutional use of the databases, it did get the media's interest perked. So now the media is again filing motions to apply pressure. We want to see this information. Now you're hiding stuff that might affect the citizens. Well, because they're doing that, now the judge has the pressure on him to start letting this information out that the defense really wants to get out. And here is the proof in the pudding, and that was that doc that just hit. Filed 1/27/25. Order regarding January 23rd, 2025 hearing transcript. The court reporter assigned to the hearing in this matter on January 23rd, 2025 shall prepare a verbatim transcript of the portion of the hearing that was closed to the public. Upon completion of the transcript, the parties will have 14 days to identify those portions of the transcript that should be redacted from public disclosure, providing a basis for the same. Thereafter, the court will release to the public a redacted transcript of the previously closed portion of the hearing. Now, I want you to use your math skills right here, okay? He just ordered that all of that information that was in that closed hearing be released to us in the form of a transcript. And he's given the parties 14 days once they complete that transcript to redact anything they need to redact. So let's look at a timeline right now. If you start this as of the 27th, it may take them a day or two to transcript this thing out. And then the parties have 14 days, 2 weeks. Now go back to the last part of that hearing, and what did Judge Hippler disclose that those counsels need to give him, and what was the time frame? Remember, 14 days, couple of days to redact what they need to redact, and then they're going to release it to the public. So that's between 2 and 3 weeks, right?
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay?
Doesn't take a math genius to figure that one out. They're going to put out those transcripts. They have 14 days to redact what they want redacted, and then they're going to release it to the public just days before that Frank's hearing that the judge will obviously grant. And he needs that information out there before that Frank's hearing because he knows that one's going to be explosive. And he's not going to close any of that one, apparently. But they're in trouble now. Let me just tell you this, because all of these hearings have been open enough to be able to gather all this new information and even garner information from the closed hearing that they, basically just let out in the open hearing. Then with the fact that they're going to release the transcripts of that closed hearing, once that comes out, can you imagine the kind of damage I can do to the prosecution's case because now I've got video evidence of them stating it in the hearings to back up every argument that I make. I've literally memorized those 2 hearings. Any argument that I make now, I can pop it right up and show it to you because people want receipts. Well, I've got video receipts from now until the end of this trial to back up everything that I need to back up. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.